people who receive subpoenas don't get to determine the protocols by which the testimony is taken. So that's sort of the pissing match, if you will, between the two sides. The question is really, why are they even bothering to subpoena him in the first place? What value do they see when, if I were his lawyer and he's represented ably by Abbe Lowell, I would just say, I'm taking the Fifth Amendment with respect to any question that you have to ask me in private, because I don't trust you guys. And I've been indicted in California, and I'm not about to jeopardize my legal case there by answering any questions that you guys have here. So it's really political theater. This is not really about truth gathering or fact finding. It's just about show.
Well, that's a pretty clear answer, I suspect, but it won't stop the process, to your point. In terms of that indictment, though, in California, he's heading for L.A. next, apparently. What's in store for Hunter Biden when he gets there?
Ultimately, a trial, unless they work out a plea deal. He's facing tax charges out there that are serious. He failed to report income and failed to file timely his tax returns worth, over $1 million in lost tax revenue. He did ultimately pay it back, but the fact that you sort of returned the money that you stole from the bank doesn't get you necessarily off the hook for bank robbery. It may get you a plea bargain to something less than bank robbery, but nonetheless, these are serious charges and he has to account for it. He has said that it was because of his drug addiction, and I understand well the problems of drug addiction in family members, and it's complicated stuff, but that's not a defense unless you're pleading some sort of diminished mental capacity. I think that he has to figure out what is the best thing for him to do. I think the best thing for him to do is probably work out some sort of plea like they tried to do when he was facing charges in Delaware, misdemeanor charges. But we'll see now whether the prosecutors out in California are, as willing to compromise with him as the Delaware special counsel was.
Well, Hunter Biden was the big moment today. Donald Trump's moment came yesterday, Michael Zeldin. This is really something as he tests this idea of presidential immunity, and his legal team got a fairly chilly reception from this 3-judge appellate panel. This is what Axios is now calling Trump's new Fifth Avenue moment. As his lawyer, John Sauer, was asked by one of the judges about this idea of, well, we'll let you listen.
Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
If he were impeached and convicted first. And
so your answer is no.
My answer is qualified yes. There's a political process that would have to occur under the structure of our Constitution, which would require impeachment and conviction by the Senate.
Imagine SEAL Team 6 being used to assassinate a political rival. Maybe you can imagine that. The idea here, though, Michael, is that if not impeached and convicted, then you cannot, in fact, criminally prosecute a former president or a sitting president. Is that how you understand this argument? Does it hold any water?
That's how I understand the argument. I don't think it holds any water. And in fact, in preparation for our conversation, I went back and read the Office of Legal Counsel memoranda on these issues. Remember, this sort of came up in the Mueller investigation. Mueller said he might have, but couldn't indict Trump for the stuff that he investigated because there's a memo that says you can't indict a sitting president. But that memo goes on to say, of course, you can indict a former president. And the case law is pretty clear on that. And so it's pretty settled that the proposition that Trump is proposing is an outlier and probably will not be sustained by the Court of Appeals or even, I think, the Supreme Court.
Well, talk to me more about that, because a lot of folks seem to think that's where this will be decided. Will the Supreme Court take this up if it goes that far?
Yeah, so Joe, that's a great question. And I think the answer to the question is it depends on the nature of the order that the appellate court issues. So if this appellate court gives a 3-0 unanimous decision, forcefully suggesting that the notion of immunity for a former president in criminal matters is absurd, then the Supreme Court might say, you know what, we don't have to decide this issue. We'll wait till a more complicated issue that raises this question. But in this case, the proposition that you are entitled to qualified immunity for inciting an insurrection is so, sort of much a no-brainer that we're going to just rely on the Court of Appeals and leave it there. And remember, they asked, Special Counsel Smith asked the Supreme Court to take this straight away, to skip this middle ground. And the court said, no, we want to hear from this middle ground court. And so if this middle ground court gives them a very strong analyzed decision, they might say, we don't need to do it. They got it right. Let's get this case to trial, and then we'll have a trial in March.
So it sounds like that's what you see happening. The skepticism on this 3-judge panel, if this goes all the way up to the full-blown D.C. appeals court, do you assume those judges will feel the same way? I think that's what you're suggesting, and that means the trial does begin long before the election.
Yeah, so the rights that Trump has are to, one, let's say he loses 3-0 in this court, or even 2-1 in this court. He can then he can seek a review of that decision by the full members of that same court. I think there are 11, and that's called en banc review, total review. And that's discretionary. Those 11 judges can say, no, we don't need to hear this. The 3-judge panel got it right. Then that forecloses that. Then he can file what's called a writ of certiorari, a request by the Supreme Court to hear it, and the Supreme Court can say yes or no to that. If they say yes, and let's say that makes it to them sometime in early February, then I think the March trial date is unlikely. But it doesn't mean that it can't happen in May or June if the Supreme Court acts quickly as they did in the Nixon-Watergate tapes, and they have that power to do that.